And good afternoon. Welcome to the Hearings Examiner appeal by Faith Harvest Helpers of the Hearing Examiner's decision denying a reasonable use exception for existing non-permitted developments. The date is September 9th, 2020.
We're going to make sure that 152 has the right feed. Give us just a minute.
Certainly, yeah. Make sure they can hear us. And if you're watching, just stand by. We're checking the room 152 downstairs, make sure that the audio and visuals, everything's working.
Yeah, thank you. Test.
Yes.
Test. Can you hear me, Brian? Yeah, we're good. We're good.
We're good. Okay.
Thank you for your patience.
Yes, thank you. So the date is September 9th, 2020. I'm John Hutchings, the chair of the board. To my right is Vice Chair Commissioner Ty Menser. To my left is Commissioner Gary Edwards. And on the bench here, we have Ramiro Chavez, our county manager, Amy Davis, our clerk of the board. And we also have Robin Campbell, the assistant county manager on Zoom. Elizabeth Petrich, deputy prosecuting attorney on Zoom. And Travis Burns. Yep, okay, yep. Travis, yeah, another deputy prosecuting attorney. And a host of other folks, I don't know who they are. So with that, I'm going to go ahead and do an introduction here. Again, this is the appeal by Faith Harvest Helpers of the hearing examiner's decision denying a reasonable use exception for existing non-permitted developments. Good afternoon. As we've done the introductions, I'm John Hutchings, Commissioner Hutchings, and I'll be presiding over today's appeal. Commissioner Gary Edwards is in the room, 280, and his Commissioner Menser is joining us. Oh, no, and Commissioner Menser is here as well. And just after 1 o'clock, 1:02 hours in the afternoon. The Thurston County Board of Commissioners is now on the record in an appeal filed by Charlie Bankelman for Faith Harvest Helpers, or FHH, of the hearing examiner's decision dated June 17, 2020. This decision denied FHH's request for a reasonable use exception, or an RUE, for after-the-fact permits for the installation of a mobile home, RV cover, and garage within a wetland buffer. The RUE application was determined to be complete for project review on June 14, 2019, and the public hearing conducted by the hearing examiner was held on May 26, 2020. During the hearing, FHH forwarded a new argument not mentioned in the application or previously submitted material. That number one, the subject property is within the designated Agritourism Overlay District, or the AOD. And number two, the activities on the site should be reviewed pursuant to the agricultural RUE criteria, Thurston County Code 17.15.415, instead of the general RUE criteria in Thurston County Code 24.45.030. The hearing examiner concluded that the county's hearing examiner lacks authority to, on the request of an applicant for permit A, decide that permit B or process B should have been implemented and require the planning department to take alternative action. And this argument is outside the scope of these proceedings. With respect to the RUE application, the hearing examiner determined that FHH failed to comply with the RUE criteria because the proposed activities taken as a whole exceed the minimum encroachment into the critical areas necessary to afford reasonable use, and there is no mitigation plan to address any of the impacts. FHH does not dispute that the proposed activities do not satisfy the RUE criteria. Instead, they argue the hearing examiner failed to consider and disregarded their testimony that the subject property should be considered under the AOD and the Agriculture Critical Area Ordinance. The first issue before the board today is whether the hearing examiner had authority to review the FHH RUE application under the agricultural RUE criteria, Thurston County Code 17.15.415, instead of the general RUE criteria, Thurston County Code 24.45.030. The second issue is whether the hearing examiner's finding of fact support her conclusion that the application fails to meet the RUE criteria. Standard of review. The board's scope of review on an appeal of a hearing examiner's decision is limited. The board, acting as an appellate body, must base its decision on the original record before the hearing examiner. The board may only review the evidence that was presented to the examiner and must uphold the hearing examiner's finding of fact if supported by substantial evidence. The board must determine if the facts found by the hearing examiner satisfy the applicable state and county regulations. Because this is not a fact-finding hearing, the board will not be taking any further evidence in the form of testimony from witnesses or additional reports or exhibits. Any evidence submitted after the record was closed in the hearing examiner's case will not be considered evidence reviewable by the board. Now we're getting into the appearance of fairness declarations. In a quasi-judicial appeal, the board is subjected to the appearance of fairness doctrine codified in chapter 42.36 of the RCW. Under this doctrine, the board members are not authorized to have ex parte communication with the parties after an appeal has been filed with the board. However, if there have been ex parte communication since the appeal was filed, or communications or relationships with any of the parties that may appear to impact their impartiality, then the substance of that communication or relationship needs to be disclosed. In addition, each board member must be able to impartially judge this case on the facts contained in the record and the applicable law. At this time, I will ask each commissioner to make a declaration for the record. Commissioner Edwards?
I have not had any ex parte communication with any of the parties to this appeal, and I affirm that I can fairly and impartially judge this case on the facts in the record and applicable law. And I want to clarify that I have had contact with Mr. Pettit in regard to other county activities going on this.
Commissioner Menser?
Since the appeal was filed on July 1st, 2020, I have not had any ex parte communications with any of the parties to this appeal, and I affirm that I can fairly and impartially judge this case on the facts in the record and applicable law.
And since the appeal was filed on July 1st, 2020, I have not had any ex parte communications with any of the parties to this appeal, and I affirm that I can fairly and impartially judge this case on the facts in the record and applicable law. So do any of the parties have any objections or challenges for any board member to decide this case?
Good afternoon, Commissioners. My name is John Pettit. I am representing Faith Harvest Helpers, and I'm bringing this forward as a question because clearly in representation of even the newspaper, media, and across other meetings we've had, there's been a great deal of animosity shown to me from Commissioner Hutchings, who I adamantly worked and opposed him in his election, and he has made comments that are very derogatory towards me. And also that I've had issues with Mr. Menzer to some degree. I do respect that he's a lawyer and he understands a necessity to recuse himself if it's appropriate, because if you have personal feelings about me in any fashion that will affect the outcome to these people and their rights for the use of their property, it's only proper that you recuse yourself now. If there's so much as even 1% hesitation because I say something as to whether it has validity or not, you need to recuse yourself and make it clear on the record that you either have absolutely no concerns and you accept my testimony that I make on their behalf, or you should recuse yourself. I ask you to address that. And then there's one more thing I want to put on the record. Previously, there remains some question as to the ability of the county commissioners to rule on an appeal due to previous decisions made against Faith Harvest Helpers based upon false information previously provided for enforcement action. You have taken actions against Faith Harvest Helpers previously in interjecting for code enforcement operations. Now, I'm not sure how you deem that you can take an action against them and still be impartial in making decisions now. So I would like you to make clear the record as to how you're going to accomplish that.
All right, thank you, sir. And we've already gone through the appearance of fairness declarations, and now the applicant has an opportunity to present 15 minutes of oral argument, and the 4 parties of record who have submitted a written response to the appeal: Sabra Noyes, if I pronounce those incorrectly, I apologize, Noyes, Doreen Millward, Sydney Clausen, and Jennifer Lynn also have an opportunity to collectively present oral argument for 15 minutes. Oral argument may not present new information or evidence, but must be limited to the evidence in the record and the specific issues raised in the applicant's appeal. I understand the department will not be presenting oral argument, but is available to answer questions from the board. The board, if it has any questions, will ask them of the parties during or after argument. Do any of the parties have any questions before we begin oral argument about the process?
Commissioner Travis will.
Yes, Travis?
Yes, Chair Hutchings, that's a correction. The department will actually be reserving a response if necessary. So we'd like to reserve the opportunity to present argument in response to the appellant.
Sort of, that seems appropriate and fair. Okay.
Also, Commissioners,
Yep.
You had provided to you an objection for you to remain impartial on this matter. For the record, the board members may want to affirm based on the challenge that you received today and remain impartial or not.
Okay.
I'd like to respond, since I was one of the challenge parties, just simply to make a record that I've had no discussions with Mr. Pettit or any of the parties regarding this matter. Mr. Pettit's not the applicant here. It's members of the community who I have no opinion about or knowledge of, no relationship with. Mr. Pettit, I understand, will be an advocate of sorts, giving argument. He should not be giving any factual testimony, so credibility determinations shouldn't be any kind of issue. And I do believe I can be fair and impartial, apply the county code and the law. So I decline the invitation to recuse myself.
Thank you.
Yeah, I will also not recuse myself. because I firmly believe I can be fair and impartial. I don't know any of these folks. I haven't even been by the property. I don't recall if I have. I wouldn't know it. So I'm going to rely on the facts of the case and code and law. And I will not be recusing myself either. Thank you. Go ahead. You weren't mentioned, but go ahead, Commissioner.
Well, I believe I was mentioned in an action maybe that the board took in a prior date.
Okay.
That's right.
And I don't recall what that action is, nor any of the facts of that. I'm not disputing that the board might have taken some action, but so I don't feel I'll be affected one way or the other, and I feel I can rule impartially.
Thank you, Commissioners.
Yes. So the time will be set for 15 minutes.
Yes, we'll keep track of this,
We're doing it up here?
right here.
Oh, right here, okay. And
And we'll give a 5-minute warning when the time comes, just to give you a heads up.
okay. Do we know how many folks will be speaking?
I don't know. I'll be the primary speaker if I have extra time. I may refer it over to one of the other people here.
If there's any time remainder, you will give the time to others.
Thank you. All right, sir, go ahead.
Thank you, Board of Commissioners. I believe that the fact is that we're not entering anything new that hasn't been on the record. Everything that we're going to talk about today was in fact submitted into the hearings examiner process and presented to the hearings examiner in the process. The issue about the AOD, clearly, as you can find if you look at the record of the hearings examiner, was addressed under item 27, of which at that point the hearings examiner had taken note of the AOD and the area which it would apply. This is a perfect example of the fact that the hearings examiner vastly failed to find proper information and factual information. And for that, I can present to you something that is clear, since you aren't going to see it just on the wall or in the ceiling. I can present to you the fact that this is from the map that's provided off of the website for Thurston County. This is the entire county. This area here is the AOD, overlay area. This here is the location of the subject property that's located within that area. The location of it is the north side is north of 113th Avenue. Their property is about a mile down the road from it. They're a mile within the district. So the first issue is that the element of the AOD is not in question. It was wrongly assessed by the hearings examiner, and partially because she was given bad information as the other detailed facts, finding of facts that she gave, including that from the CPED department representative and how that would apply. That being said, we now go to the fact that we entered this into the hearings examiner prior to the hearing ever starting, and the direction that we were given to bring this forward into the hearings examiner was actually one that Joshua Cummings had directed us to do. In fact, he had said particular that the opinion, if we're here relating to this, has been relayed to his employees who chose not to put it in. That being said, he put in here in a letter to the people here, the next available step is to reschedule the RUE, the reasonable use exception hearing with the hearings examiner. The RUE hearing that was postponed until your request from there remains available to you as the most appropriate path forward. So these people put that in. The hearings examiner completely ignored it because the CPAD representative failed to put it in their report, which is in fact part of the record. In order for any property to be evaluated and considered, first you have to know what the property is. Just because you have two pieces of property, one side by side, because the AOD is for only 10 acres or greater in size, the fact of the matter is when, if you had a 5-acre piece next to it, it doesn't qualify. But with the agritourism overlay district, it changes everything. And as you already would be aware, if you were aware of all of county codes related to this, that under code 2008G015, if a specific AOD standard or regulation conflicts with other specific development standards in the Thurston County zoning ordinance, Title 20, the AOD rules and standards shall apply. That's that simple. This is a primary element of their use of their property. It's not a condition. It's not something you have to apply for. It's an automatic brought forward right of ownership of this property. This AOD would even override a commercial standing. It overrides, and the standards meet it. On top of that, when you go into the agritourism element, you also have to go into the fact that that changes your critical area ordinance application. And the reason why that's important is because the lack of the hearings examiner accepting the AOD as being presented continued. And you can find it in her report time after time. I've listed a long list in it previously that they were dealing with Title 24. Title 17, which really has very little in it that you're going to actually see, because what it does, it sends it over here to the state law. And under the state law, it provides exactly that everything that's been done by these people have complied. The setbacks for a building that's already existing has no buffer setback in addition or consideration. It was inappropriate from day one when they were directed to even go towards the RUE because they hadn't considered their property properly for what the uses are allowed for under county code. I think of this particular session, yes, I am arguing certainly against the hearings examiner's decision. Good decisions can't be made on bad information. And there's an immense amount. It's going to take a tremendous amount of work by you guys. If you're going to dig into it and say, what's these people's property rights? Let's start at the top. Because you have a process here. Under Code 2.06080, Board Action on Appeals, the board decision on appeal at the close of the record appeal meeting the board may adopt, amend and adopt, reject, reverse, amend conclusions of law and the decisions of the hearing examiner, or remand the matter for further consideration. It's not as simple as just saying, oh, no, we're going to go with that because it's convenient. It's about getting to the core of the law. And the core of the law lets these people have the right to use their property. Now, we're talking about the buildings in which we're in question. One of the buildings was built back in 1990 or earlier. That building was established in the record. It has been there for all this time. They paid taxes on it since they bought it. And now the county says, nope, sorry. We don't have a record of a building permit, so now you're going to have to apply for permits. These people have done everything. This was mentioned in the hearing. Everything that the CPAD department told them to do. They aimlessly tried to comply. Of course, they didn't know when they were doing all this, they were complying to RRR 1 per 5 acres. They didn't even realize that the agritourism overlay district existed. Nobody told them. This has cost them thousands and thousands of dollars to go through this application process. It cost $4,800 just to go to the hearings examiner, and we get a report that's as defective as this is. You're going to have to start from ground zero if you're going to make a good decision of what you're going to do about this report, whether you're going to override it and set the record straight with these people having the right to use property accordingly, or whether you're going to decide, well, that's a lot of work, we'll just go ahead and go along with it. People need to be held accountable. Now, I want to express that if you really want to go back in the records, you really want to research, you'll find that there were 3 septic systems on this property and 3 mobile homes on this property. They're not even adding any more than has previously been in and located on the property. But yet, through the process, they have paid hundreds and thousands of dollars for applications for permits that have been held away from them.
5 minutes.
5 minutes? Thank you. I do get wound up. You've known me very well, and I get very wound up, and nothing causes my heart to be more wound than people being violated of their rights. Now, I came into this entire process. It was just right after the action that I talked to previously about, that the board had taken an action with CPED, because I was sitting here and watching when that meeting was going on. It appalled me. I made a call. I volunteered my services in order to try to cross the barriers and communicate. We have met with virtually nothing but defiance from CPED to follow the law. They couldn't decide. Well, tell me what agritourism you're going to do. Well, excuse me, this is a right I have. If I want to put a cow on there, that's my choice. It all has a category laid out in law that says what you can do. If you feel like as though property rights aren't important, then you just pass on and let this abuse continue. Otherwise, you need to dig in, give great consideration, and take the opportunity to make the record right. This is an opportunity to move forward without any further action. And that is what every commissioner should want, is to encourage people to have the right to use their property. So I'm going to, certainly Charlie or Paul, would you like any time at all? No, you're fine. Okay, well, in closing, since this is my first round of close, I presume I get a rebuttal to other people. I think if anyone makes a testimony, I presume that we all should be considered that what we're testifying to is under levels of perjury. And you need to be able, judicial proceeding. You need to make sure that if people are saying something, it's true. They've been accused of canning salmon on the site. It never happened. It's a bogus claim, and it's in the report. It's in the findings. Things that never happened. It needs to be, the record needs to be straight, and they need to be cleared. They need to publicly be apologized to because they were maligned through the media. And they are the victims in this case. And quite honestly, if I was going to say anything else, I think that the county probably should be reimbursing them funds they've spent just to try to get their basic rights, but through all the misdirection they've had. If you have any questions, I'm open to it right now.
So you may want to reserve the remainder of your time for
I'll
a
reserve it.
rebuttal.
Thank you.
Okay, so it's 2 minutes left that you have. Thank you.
I do have a question.
Do I want to go from questions from the commissioners or find out there's going to be a rebuttal? And I'm looking at either Elizabeth or Travis.
He reserved 2 minutes of his 15 minutes for a rebuttal.
But if we ask questions, that might be it.
But at this point, you can ask questions.
Doesn't take out of his time.
Okay, the last question, go ahead. If you have questions about
Yeah.
the case, you can bet.
Yes, I do. I have questions about what Mr. Pettit just got done saying. Okay, so I'm going to ask staff, I guess, the same question if they are willing to come forward. So this map that you've showed us, you're alleging that this ag district, this property in question is in the ag overlay district.
That is correct. It's in, the north boundary is about a mile north of this site.
It's like within a mile of the district.
It is a mile inside of the district.
Okay. Does any of the activity that is taking place or is going to take place, does it fall under the agricultural side of the regulation, assuming you're right, and it would fall under 17 rather than 24, the county code 17 rather than 24?
Okay, for clarification on that. Title 24 is a critical area ordinance that's related to general residential development and general residential properties. Title 17 is the agriculture critical area ordinance. There's a difference. Now, one requires certain setbacks and requirements, the other requires different setbacks and requirements. Everything that they're doing on their site is all within the boundaries without any further consideration of a Title 17 would allow them to do under the critical area ordinance, Title 17. And the second part to that question is this what agritourism is? Everything they have and they do over there is completely within the boundaries of activities that are outlined within agritourism.
And then maybe my last question here, I'm close to the last anyway. This fish processing issue about fish, is there anything to do with fish on the property? I guess that'll be my question.
Okay, the only thing these people have ever done with fish is upon guidance from Washington State University and county associated people, they used it and planted it for fertilizer purpose for their gardens. That's it. They have never processed fish on the site. It is a ridiculous accusation.
Okay, and then I guess one final question. How do you explain this discrepancy of the location of this property being within the AOD when county staff is saying it's not within AOD? I don't know if it falls within the argument or not, but there's a big discrepancy of the location of this property being in or out. How do you explain that?
Well, all I can really relate to is the fact of what my knowledge is. It's clear, it's within.
Could I see the map, please? I guess I need to see it closer. My X-ray vision there isn't working here. Okay, thank you. Yeah, go ahead now.
I cannot explain why county staff would not be able to run the geodata maps which indicate the exact lines and boundaries of the agricultural overlay district. I happen to know that this was brought up completely, even in personal session with Josh Cummings, Brett Burris, in a session of trying to deal with getting this adjusted and allowing them to move forward. They wanted consideration. Well, we got to think about this. But it was directed by the letter there that it was going to be referred over to the staff, and staff never adjusted their documents from 2019 to incorporate the fact that the property is not just RRR 1 per 5, but it may be RRR 1 per 5 within the agritourism overlay district, which changes everything because that is, in fact, the overriding element in decision process.
Okay, thank you.
Hey, Commissioner Edwards, this is Heather Burgess. I'm counsel for Ms. Clausen, who's one of the parties of record. And being on the Zoom call, with apologies, I'm having a little bit of difficulty identifying which exhibit to the hearing examiner's decision Mr. Pettit is proffering at the moment so that I can cross-reference it with my record.
Oh, okay.
Yeah, let me, hold on.
Thank you, Heather.
I understand what he's represented it to be. What I'd like to know is what exhibit, oh, thank you, Romero. What I'm trying to identify is which exhibit to the examiner's decision this was specifically, because that's what this is supposed to be based on.
Right, that makes sense.
Yeah, this is
You were looking that up?
included on,
I'm currently trying to look up to see exactly which number. It was in one of the, I believe it was 12 or 13 exhibits which showed the map, including the exact location and acreage. So if you go through the exhibits and actually look for yourself, Ms. Burgess, you would actually be able to see the map, and it is color-coded and directed there. I realize that we're you're trying to gain new ground to try to say, well, that's not in it. There was a map supplied in the documents supplied to the hearing examiner showing this property as being inside of the district.
Right, it would have been nice to have you reference that exhibit so we wouldn't have to take time looking for it now.
Well, I would love to help you, but
It's in here somewhere, huh?
it's in there, and I believe
Perhaps.
it was probably either J or K. It's one of many documents, and that is available for you to look at. And I'm sure Ms. Burgess, if she takes the time, she can take a look for herself. It's right there, too.
And I just want to restate my objection for purposes of the record that I don't believe it's incumbent upon the parties to locate an exhibit. And to the extent that the commissioners are going to base a decision upon this information, the appellant should have to identify specifically which exhibit admitted in the record this was. Thank you.
Do you have any questions of Mr. Pettit? Commissioner Mentor?
Yeah, so if you're right, set aside the maps.
Okay.
Assuming you're right about the or that the agriculture overlay district is applicable, you believe that there's no application of the reasonable use exception under 1715-415 because, can you flesh that out for me?
Okay. Number one is I don't think you're going to find that there is any application provided for in 1715 or an RUE, okay, as such. I wasn't really sure where that was being read from. Reasonable use exceptions typically are part of county code in order to seek to have consideration by a party such as a hearings examiner. I'm not sure 1715, I don't see anything when I've read through it, but once again, I can't identify it all in front of you because the majority of that code is directly sent to you directly over to the state RCWs, which give the line item about buildings, repairs, and everything. That's all in there. There is nothing that I saw that would require any element that would have triggered the need for any RUE at all in this process if the correct critical area ordinance had been applied.
You are familiar that there is an RUE embedded in 1715.
Well,
And it's different than the other one, but really, really similar at the same time.
well, I would have to take a closer look at that because I don't have it in front of me, but I'm sure with your due diligence of wanting to find justice to be served here, that you can certainly incorporate it and apply it. I can assure you that under the state state law and that the element of existing buildings do not have to be changed or subject to it so long as they're not being extended any closer to any considered wetlands. That is without question. So,
So just to finish with the point, if that provision, if the RUE provision of 1715 was triggered,
right,
you're not necessarily contending it's satisfied. You didn't walk through that analysis. You're trying to basically argue that it's not triggered to your understanding of Title 17.
that would be correct.
That helps zero in the issue here.
That's zeroing in the issue. That would be correct, but I would assume, and this is me assuming, and you can go through your own verification, that when considering the agenda for 17.5, which the hearings examiner also did not do, that could help you evaluate whether or not it would meet the criteria for an RUE under that particular criteria.
I think that's enough for what I need.
Thank you for that, because that was one of my questions, the differentiation in contrast to the two cited county codes. And thank you for upfront stating that nothing new is going to be testified or admitted today. But I have a question regarding, you said CPED failed to include, was it the AOD into the packet to the hearings examiner?
That's correct, Your Honor.
Okay.
I would suggest that you can take a look at the actual document filed with the hearings examiner from the county. You will not find anything that was provided there listing the AOD as being a factor in the consideration of the property.
Got it, okay.
I would like to say that I did find a map, a vicinity map that is similar to the one that was shown here, that shows this property is just to the north of Maytown on Case Road. A vicinity map showing property location. Now you're going to ask me what page that is, and I don't see a page number. So,
While you're looking for that, I have no other questions. Thank you. Are you just finding the reference and noting it, or did you have more
yeah,
questions?
no, I guess I'm kind of curious to hear from staff what they've got to say. It is or it isn't?
This matter is related to the hearing examiner's decision.
Yeah.
Well, I'm looking for justice, and that's one of the things I'm going to be asking about. The hearings examiner apparently stated that this information would not be applicable even if it was in the ag overlay area. I'm kind of waiting for staff to hear it. I'm not going to limit myself and try to make a decision lacking information. That's
You certainly will have additional time to get
Okay.
additional information if you need to, Commissioners, before you make a decision.
I don't have that exact map, but I sure have one that looks like it.
Is staff going to chime in at all at this point or not? Go ahead, Travis.
Yeah, Commissioners, I plan to do my best to address some of the claims and concerns during my opportunity to respond. So, whenever that makes sense, I'd happy try to address. And if you have additional questions, I'm also available. Right now, the staff won't be testifying because it is a record review, but I'm happy to try to address the concerns.
Okay, fine. I don't have any questions. Do you have any questions of Travis? Elizabeth? Any questions of Travis?
Yes, I guess if you're going to be talking to us about this, will that be in a public setting or an executive setting?
This will be after the other party have the opportunity to exercise their 15 minutes. Then I will ask for you to consider Travis to come back and address some of the questions that you heard today.
Okay, and that'll be in a public setting?
Today.
today. Great.
I know.
Good.
I think,
And this can be over. I already canceled your 3 o'clock.
Okay, go good, thank you. And you canceled the 2 o'clock.
Oh, the 2 p.m., sorry.
Okay.
Canceled at 2 p.m.
Thank you. So is there anybody else going to be testifying today? Any other parties?
I believe Ms. Heather Burgess is representing the
Okay.
elected
Elizabeth?
Yes, Commissioner Hutchings, if I may, I'm not sure what Romero said, but Travis is here on behalf of staff to present argument to you on the record about the case in front of you. It's not appropriate for Travis to go into executive session with you to discuss this case.
Right.
I didn't get what the echo, what she was saying. It's not appropriate for Travis yet?
So, no, what she's saying is Travis is going to provide testimony after you give the other side 15 minutes on today's meeting.
Okay.
Travis will not be joining you on an executive session tomorrow.
I think the use of the word testimony is confusing. Nobody's giving testimony. He's presenting argument.
Yeah,
in the
it
question
provides some.
on behalf of the whatever, the
Okay.
responding party.
Okay.
And it's
So
his
then
turn
we'll-
to do that.
So now we're going to turn to Heather.
Yeah, and she had 15 minutes, and I believe members on the public on 152, they would like to provide testimony, but I will be part of the 15 minutes if Ms. Heather Burgess would like to give the floor to any of the individuals in room 152.
Did you get all that, Heather?
I did, thank you. Just to clarify, this is Heather Burgess. I only represent Ms. Clausen, one of the property owners, and I'm only one of the parties of record. So it would be inappropriate for me to collect everybody else's in 15 minutes and utilize those. There's a number of individuals who appeared at the hearing pro se who are parties. And so it wasn't clear in the instructions, to be candid, how the time of this 15 minutes would be offered or allocated. So we haven't had the opportunity to discuss that prior to the hearing, and I don't represent those folks. So there's a couple of things I wanted to make, and then I'd yield to the next party in order, either in the Zoom call or they're present,
Okay.
pursuant to the, whatever the commission's protocol would be in that regard, if that's okay with you.
Yeah, we'd love to hear from you. Go ahead.
Okay. So there's a couple things here, and I did make a written submittal on behalf of Ms. Clausen that includes some fairly technical arguments and detailed references to the code. And I'd like to point you in particular to the fact that there is, in fact, a reasonable use exception criteria available to agricultural uses that was not applied by the hearing examiner in this case, but the agricultural overlay district, to the extent, agritourism overlay district, to the extent it would apply here, which I don't agree with, is still not a get out of jail free card when it comes to land use regulation in Thurston County. What it does is provide some additional flexibility and latitude in certain land uses and regulations. However, even with agricultural uses that fall within that overlay, you still have your base critical area regulations that would apply. So that's a general overview. My more technical concern here is that your hearing examiner here is a creature of limited jurisdiction, meaning she can only appropriately consider the matters that are presented to her. And in this instance, what was presented to her was the applicant's application for a reasonable use exception pursuant to Title 24. The applicant applied for that, presumably following discussion with some kind of discussion with staff, and sounds like in response to certain code enforcement, which is not uncommon in after the fact permitting. If the applicant had an issue with that being the appropriate venue or application to remedy the situation, then the appropriate mechanism for the applicant would have been to appeal the department's determination of the requirement for the permit and or the applicable code at that time. Thurston County actually has quite generous administrative appeal provisions for administrative determinations. So to the extent that those were made, that is the remedy, not a wholesale redo after the fact of a hearing examiner's decision. So again, the hearing examiner can only find that which is put in front of her. And I believe that the examiner's decision falls within the four corners of her authority and should be upheld. And I'd yield the rest of my time to any of the rest of the parties of record. Thank you.
Thank you, Ms. Burgess. Do we have people downstairs? Do we have somebody monitoring downstairs in case those folks would like to come up?
Yeah, so we have paused the clock. We have just about over 12 minutes. For those individuals on 152 who would like to provide testimony, can you please come up? We'll give you the time to come to room 280. Also, for this room, we have a capacity of 10 individuals. I will ask to probably leave and join us on 152 because we cannot have more than 10 people in this room. So depending how many people
see how
may
many
come
come
from
up.
152,
Yeah.
I may ask you to change that.
I guess, could I ask you that you clarify something that no more than 10 in a room that has to do with the governor's
Yeah, that's
regulatory stuff, right?
that's the phase 3
Okay.
regulation.
Okay, so let's keep the conversation down, please. Thank you.
So please, can somebody vacate
Someone
the
needs to
room?
remove themselves for a little bit.
And you can follow the hearing on room 152.
You can still hear what's going on.
Ma'am, do you know if anybody, oh, we have more people? Okay. Thank you. Perfect.
Thank you so much. Appreciate with your patience with the logistics.
Yes.
So give us just a minute until the individuals who were here can make it to 152, and then we'll give you the time for you to provide your
And then when you do begin, when we give you the go sign, please start with your name then as well, so we have you for the record. Were there other folks downstairs in room 152? No? Okay, so we shouldn't expect any more coming up. Good. Yeah.
Yeah, we'll give the time. We'll keep the track of this. Okay. Okay, if you're ready, ma'am.
My name is Doreen
Oh, are you
Millward.
ready? Okay. Go ahead, ma'am.
I'm Doreen Millward, and I'm a party of record and live near the property in question. And I want to point out that they, as far as their reasonable use permit, they haven't proven any reason to have it. They haven't justified anything. And instead, they're deferring to this agricultural tourism overlay district. And I was the one that presented some mapping. It's in Exhibit 4B. And I will admit there is confusion. There's the Bountiful Byways map, which has in shaded area the location of the overlay district, and the property is clearly north of it. And this map is dated from February 2014. The map on the website that also is supposed to show the agriculture overlay district is dated January 2014. The code definitions of what the agriculture tourism district is, it says it's as defined by the official zoning map. If you go to the official zoning map, there is no overlay district shown on that map at all. So there is a lot of confusion, I will say. But aside from whether it is or is not in, the uses that are to promote agriculture do not include a worship center, ministry, campus, and those are all the things that they are striving for until just recently that had all been displayed on their website, including the fish canning, which they do and intend to continue doing. They have a lot more structures on their property than what is shown on the site plan and anything that has been presented to you. They have all these semi-cargo containers, and it's full of equipment that they do a lot of extraneous activities that they have no permit for. And that's what we're afraid of, is all the dumping of the fish guts. They have been charged with violation notices at least twice that we know of, that's in the record. And I have in the record below, it's Exhibit 2A, I submitted an updated letter, and I submitted a whole packet of information about it, and I included photographs of their property, and I would hope that, well, I think the whole point of what they're trying to say here is that they have no intention of following the regulations that exist for everyone else. And Mr. Pettit has contrived this tourism district to mean something that does not exist on the books. It would be an abuse of what the county is trying to have with their tourism, agricultural tourism zone. It doesn't include the things that they're doing on the property. You know, if they want to have a cow or show some kids a growing tree, that's great, but that's not what they're doing. They have a lot more going on, and I don't want to take up everybody else's time, so that's what I have to say.
Thank you, ma'am.
Would you like to testify, ma'am?
You like to come up to speak? Yes, ma'am. Thank you. You just identify yourself, and then for the record. And how much time does she have?
We still have 9 minutes and 21 seconds.
9 minutes, there you go.
So we still have time for some zone people?
Yes.
I need to leave that in my 9 minutes? Okay. Thank you very much. My name's Jennifer Line, Lyne. I live right across the street from the Faith Harvest Helpers place on Case Road. I'm familiar with this. I taught orchestra for 44 years, so everybody always watched my backside from the audience, so I'm kind of used to this. Sorry.
You're fine.
Back to what we're here to talk about. Again, as in almost every piece of writing or evidence or testimony, what we've said over and over again is the codes of the county are not being followed. For instance, things are being put together. The second double wide was asked for a permit after it was built. That's what I've seen over and over, and I've looked at the documents. I requested the public information. I've read hundreds of pages of not only just the documents, but the detailed information from emails from county back and forth, where county members bent over backward to help these people understand what codes are required, what is wetlands, what is a buffer, what's involved in all of that. And over again, they not only help them, but they filled out the paperwork wrong, or it was illegible, which you see in their presentations. And this county kept trying to help. In fact, I just watched Mr. Burris out in the hallway wish them good luck in their appeal today, which I sort of felt was a little bit inappropriate. So the other thing that we're concerned about is consistently in their web comments and goals and such is to develop this as a campus. One of the big deals of the YWAM FHH, which is throughout a big campus down in Salem, is they train missionaries. They charge them, they stay there for 5 or 6 months, and those things are on the website. I think it was about a week ago. I looked again, and it still was there. So it's agriculture. Even the cows on the land don't belong to them. For I don't know how many years, probably 15 years, Brett Hale has leased the land for his roping cows, that he teaches people how to move cows and, do cowboy stuff. And they come for the summer and they graze and they have calves and then they go away in the wintertime. So I'm sure they're still getting that, but they are not ranchers themselves. So again, we want to see all of us read the codes, read what we're supposed to do to make Thurston County a wonderful place, and we want to follow them. And if we don't know what's going on, we want to come and ask questions and do it the right way. We don't want to do it behind people's backs or after the fact. And I think that all of the evidence the hearing examiner looked at was interpreted properly. Thank you.
Thank you, ma'am.
We still have 5 minutes and 45 seconds for whomever wants to join. use the other
All
side.
right, there's still 5 minutes and 40 seconds left. Heather, do you have anything? Ms. Burgess, anything further?
I do not. Thank you, Commissioner.
Is anybody else who's joined us via Zoom would like to provide testimony using some of the 6 minutes and 45 seconds?
Yes, if so, just,
Please unmute
Unmute yourself.
yourself.
This is Jennifer Line. We also would like to know if the water quality of the septic systems has been re-examined and approved, and see some kind of certification of that. The electrical systems that were put in, electrical and water for RV pads, to encourage families to come and worship the Lord and help by doing work while they were there. If, you know, I'm not sure if those are still operable, but they were right on the edge of the wetlands. And also, is there electricity and water being plumbed to the pole barns, which was forbidden to be done? Thank you.
thank you, ma'am. One last chance for anybody that's on Zoom. If you'd like to testify, please unmute yourself and you can address the board.
I think she,
She will, ma'am. Just giving people on the Zoom call.
no, I know, but it looks like Doreen wants to come up again.
Okay, now that I have a couple more minutes. The code, there's been nothing that says that this property automatically, it gets deferred to that chapter 1715, which would apply for existing and long-term agriculture existing. There's been no evidence provided for that. And then as far as the agriculture, the tourism overlay district, of the uses that are allowed, it's not carte blanche. You have to there's uses that you have to apply for permits. There's some that are exempt, but even the exempt uses, you still have to comply with health, sanitation. That's my main concern about the property, is they're doing willy-nilly anything they want, ad hoc, putting in septic systems, digging them wherever, and dumping fish guts in the wetland. And that's what we're concerned about. And so the two big pole buildings that they had, one of the conditions for the permitting was that they were supposed to correct all existing violations. They did none of that, and they built those buildings and finished them up. And I'm forgetting what I was going to say, but there's a whole litany of requirements in the agriculture tourism thing that you can do jams and jellies and sell them on the property. You can't do fish canning and give it away to the food banks. Don't you think that the people that are in the food banks getting that fish, don't you think they deserve to have some sort of quantification that the food that they're getting is safe? There's none of that that's going on. It's terrible that a religious organization would be lying, but they are. So.
All right, thank you. Just note for the record what time is remaining.
Yeah, there is 3 minutes left. If for this item they'd like to have a rebuttal, Mr. Pettit.
Mr. Pettit.
Minutes.
Hold on, we never got the
Oh,
department
questions, I'm sorry.
presentation.
Question.
No, I mean, the presentation from the department.
I think it's at the end of the.
After Mr. Pettit's rebuttal? No, he gets a chance to rebut after.
Yeah, so it's
presentation.
within your, whatever you.
Okay, are you ready to go, Travis?
I have some questions of
Okay,
this.
hang on, we'll be one thing at a time. Are you going to present, Travis, or not?
Whenever you're ready, commissioners.
Okay. And your question for?
This last presentation. I've heard this referred to as a ag overlay district, an AOD, and I've heard it referred to as an ag tourism overlay district. I guess I'm curious, can somebody, what's the term? Are we talking about the same thing? Are we talking about two different things? What's going on there? I don't know who's got the answer.
Well, there's the agritourism, obviously, and then the agricultural overlay.
Well,
I was referring to the agriculture overlay, the agricultural tourism, and I've been misspeaking a lot of the time.
It's two different things.
so are we dealing with an ag overlay district or an ag tour overlay district? I'm just trying to figure that out.
We might get that in a little bit.
Can't staff, can't somebody tell me what the deal is there?
We'll provide that clarification for you by tomorrow. Yeah.
Well, I guess in that case, I'd like to hear from Mr. Pettit. If somebody can tell me, that's all I want to know.
In regards to your question, it is
This
agritourism.
answer is not counting against your time.
Right.
Okay.
To your question, this is an agritourism overlay district.
Agritourism overlay district. Okay.
Which has a long list of multiple elements which can be applied for and used for that area, of which hopefully when you review the process and take a look deeper in, you will have more knowledge about what that encompasses.
Okay. And then for the ladies that just presented, there was some mention of fish guts in the water or something. Have either one of you actually seen a canning program going on there? Or how did this come about? I'm trying to figure out what's going on there. Yeah, you can both come up and help me out, help me figure it out.
I think it was in 2016 or 2017, county inspector was on site doing early on whatever kind of inspection, and a pickup truck drove in with two 55-gallon containers of fish entrails, and a hole had been dug back in the wetlands area, and he drove right past the examiner and dumped them in there and drove out, and the examiner stopped him and made him clean them up, and he got a red ticket, which I don't have a copy of that, but I'm sure county people could find it.
And that's part of the county's record of this?
Yes, that's part of the county's record.
And was that being put on a garden, you know? I mean,
No, it was being
rural
dumped. It was
America, fish guts are
in a
used a
hole.
lot in a garden or for compost.
But in the wetlands, it was done in.
Okay, just trying to figure that out. Thank you.
Okay. Mr. Pettit?
So just to make sure, what I have for you for staff to bring is maps related to the agritourism district and a map related to the agricultural overlay.
So don't tell me there's two maps.
I think it's
Two separate, different maps?
things. So we'll bring those maps to you before you, so you're well informed about before you make the decision.
Okay.
Yeah. Mr. Pettit, you have 2 minutes remaining? What is it?
Wait, no.
I think Travis will, Commissioner.
Yeah, we've missed a party's presentation, the department.
Oh, okay, so he's going to go before Mr. Pettit.
And then
He refuted it.
Mr. Pettit gets the last word
Makes sense.
after all the presentations. I think party gets the last.
There was some more time?
There was
You
3 minutes.
have 3 minutes, but you can reserve that to later if you like, or you'd like to use it right now.
Okay. Travis, if you please, sir. Mr. Burns.
Okay, thank you, commissioners. Chair Hutchings, board, thanks for the opportunity to present argument on behalf of the department. Just to be sufficiently clear here, make sure there's no misunderstanding. I do represent CPED, the department, in this matter. I do not advise the board, and so, you know, I am from the prosecuting attorney's office, but I do not represent you in this matter. I'm presenting argument on behalf of the department, and at least, you know, to that point, I want to mention that, point out what CPED staff are charged with doing. In these kinds of situations, they present factual information to the hearing examiner in a way that can render impartial, objective, and accurate decisions by their hearing examiner. So whether it's a special use permit or a reasonable use exception that is at issue today, that is what these staff are attempting to do. Before I get into the merits, I do have to just formally lodge an objection. The appellant did raise, or at least refer to, a number of correspondences and discussion between head's director and management. And to the extent that that's not in the record, that should not be considered by the board. You know, again, I know at least some of those statements were not in the record that I'm aware of, but again, to the extent that that's not in the record, this is closed record review and that shouldn't be considered. So, you know, I'll just jump right into the merits here. Faith Harvest Helpers are challenging the hearing examiner's denial of their application for an RUE. And what you just heard here was a plea for the board to exempt or really waive the applicant from having to secure an RUE in the first place. In fact, you heard the appellant say, hey, we don't even think the RUE under 1715 process applies. We believe, and this is this is the nature of the argument, we believe that we are exempt outright. Now, what's very critical for you to recognize in reviewing this case, that is not the issue. The board, just like the examiner, must evaluate whether the application that was submitted and offered by Faith Harvest meets code requirements. And by the way, when you review Exhibit 1 in the staff report, there is a copy of the application, and the applicant actually addresses the 8 criteria that are needed in order to satisfy the requirements under Title 20. So indeed, they did apply for an RUE for an exception to, Title 24. They did apply for an RUE for reasonable exception under Title 24, and that's what's before you today. So the question here today is whether the hearing examiner's denial is supported by evidence in the record. Now, you may decide, yes, the record supports the examiner's denial. You may also decide, hey, no, the RUE criteria was clearly met, and the examiner ignored, maybe testimony in the record, documents offered by the appellant, and you may decide, hey, the record just doesn't support the denial. But either way, it's the RUE criteria that is at issue, not whether the 3 structures are in violation in the first place. And that's an important point because that question has already been answered. And some time ago, the department issued a notice of violation, as is customary in most of these after-the-fact permitting situations. Faith Harvest at the time appealed that NOV, but soon after decided to withdraw its appeal. Now, they can't turn the clock backwards. They abandoned their option to contest the violation or to make the claims that they're making now that the critical areas somehow do not apply to their property. And, by the way, there's the argument comes twofold on that point. They're both arguing, the AOD, if it's applicable, exempts them from doing what they're doing. And they're also arguing that, hey, you're under the wrong title, that Title 17 should apply. And as he's mentioned, things that qualify under Title 17 are, include things such as, it must include maintaining, repairing, and replacing agricultural facilities. And commissioners, in this case, we're not repairing, maintaining existing facilities. We're doing after-the-fact permitting for the facility because it was never done in the first place. So Title 17 doesn't apply. That's not the issue, though. The point is, the question's not before you, and it wasn't before the hearing examiner. The limited purview is to decide whether the decision as issued by and applied for by the applicant was appropriate. And so I don't want to get into a long litany of discussion about what those things are, but because there are a lot of questions about AOD, that's another. Again, even if the property is within that area, it's irrelevant. In fact, staff probably didn't include it as part of his report because it has no bearing on whether or not the RUE should be awarded or not, or whether it should be exempted. The AOD, and just to be sufficiently clear, allows certain uses, agritourism uses that are enumerated in that part of the code, in addition to any other uses they can do under their residential zoning. So there are certain uses that are exempt from land use permitting. However, structures still need to meet code requirements, and that's sufficiently clear. So, again, I know there's a lot of questions of whether or not AOD is whether this property is within that area or not. I looked at the staff report. They did not mention AOD. If the hearing examiner found that it was outside the AOD, I would consider that to be harmless error. But in any event, the question, looking back at the beginning of this thing, what's before you and what you need to decide, the question is whether or not the denial was appropriate, not whether or not they are exempt from the application process that they voluntarily went ahead and submitted for review. So I'll go on with the, what is at issue here, and that's Thurston County Code 2445030. These are the criteria that they attempted to address in the application, in the record. And this includes 8 criteria, all of which must be met before reasonable use can be legally granted. Now, the burden of proof is on the applicant. Nonetheless, they submitted little to no evidence to satisfy this code criteria. Now I'm going to go through each one of those criteria, and I'm going to quickly cite portions of the code that do not support the notion that they should be approved. And this is twofold, just to illustrate that there's little or no evidence in support of the applicable code, but also to show that the hearings examiner did have a basis and sufficient evidence to rule the way she did. So, and I will mention, I'm going to cite to the record here, and if there's at least a request, or if you want to list those references, I'm happy to provide those after the hearing at your option. But I'm going to go fairly quickly through this since I don't want to take up too much more of your time. Criteria A, is there no other reasonable use of the property as a whole? No, the residentially zoned property is legally developed and allows for a single family residence, at least 2 septic systems, 2 pump houses and associated water infrastructure, and 2 pole barns. These are reasonable residential uses. Hearing examiner decision, page 14, paragraph 2, and page 6, paragraph 9. Criteria B, are no other reasonable uses with less impact on the critical area or buffer possible? Now, at a minimum, the code requires the applicant must review alternatives. No alternative was reviewed or discussed by the applicant. See staff report exhibit 1, pages 4 through 5, examiner's decision, page 14, paragraph 2. Criteria C, would the proposed use result in any damage to nearby properties? Now, this is a contested point, but I should mention that in the record, the applicant claims there's no damages, simply stating that development is not big, has been around for a while, and has approved septic at some point. This is at least contradicted by certain statements in the record. It's not necessarily clear whether the landowners are damaged, but there's certainly sufficient evidence to show that there's longstanding neighbor complaints. See examiner's decision, paragraph 23, and comments recently submitted to the board. And then for other damage to neighbors, there is a significant amount of evidence that Department of Health has a variety of septic concerns. Now they're confusing, and it involves a lot of moving parts, and whether a public system is necessary for the public if they're visiting this property. But if you look at, but those concerns exist and were not addressed in the record. Again, see staff report at pages 91 to 92, that's exhibit 1, and also examiner's decision, paragraphs 19 and 25. Criteria D, would the proposed use pose a threat to public health, safety, or welfare? Again, see the Department of Health's unaddressed concerns over handling waste and citizen concerns. Again, I recognize that there may be a dispute of fact, but again, that's what the hearing examiner is there to do, is to resolve those disputes of fact. And there's plenty of evidence in the record that support the hearing examiner's decision. Criteria E, proposed use shall result in minimal alteration of the critical area. Again, no meaningful effort or review completed to address alternatives of the 3 structures that are under review. And criteria F, proposal shall ensure no net loss of critical functions. And this is a big one. No net loss of critical functions of value. The applicant did delineate wetlands, but entirely failed to prepare any mitigation plan to offset impacts from the 3 structures. The code requires a mitigation plan prepared by qualified wetlands scientists. None was submitted. See examiner decision, page 5, paragraph 4, page 7, paragraph 12, page 10, paragraph 18. See also staff report, exhibit 1, attachment F. And then finally, G, use shall not result in unmitigated impacts of species of concern. There has been a long-standing and documented concern over Oregon spotted frog in the area with U.S. Fish and Wildlife. That's in the record. See staff report, page 7, examiner's decision, page 7. So, the applicant just simply has failed to meet its burden. The project is not approvable under county code. And as a final matter, there are several ongoing violations outside those at issue today that continue to be observed by the county and alleged by neighboring property owners. And this is, again, in the record, staff report, page 9, paragraph F, and see also examiner's decision, page 12, paragraph 25. This is important because under Thurston County Code, you can't have any other land use approvals when violations persist and continue on the property. So in closing, the RUE application fails in multiple respects, and the board should uphold the hearing examiner's denial. Thank you, and happy to answer any questions if you have any.
Do you have any questions? Mr.
Yes. So, Mr. Burns, I know you don't want to concede that the AOD applies and that it's relevant, but I'm going to pull you there anyway. Ms. Burgess's comment said something to the effect of, she didn't concede it's applied either, but she said if it did, there's some additional flexibility, but the agricultural critical areas ordinance still applies, not a get out of jail free card is what I wrote down. Then you, I think you expanded on that a little bit by saying that that flexibility manifests in certain uses being permitted, but you said that might not need permits, but buildings in any regard are going to need permits. So my question is, taking that one step further, is there any difference in the type of building permit decision under the agricultural code section that would differently trigger the critical areas, or the reasonable use, the necessity for a reasonable use exception as it's laid out in 1715-415. I hope that question's clear. Meaning, is there some difference? If you're inside of this agricultural district, is there some, you don't need as much of a buffer, or you can impact the wetland in a more substantial way than you could if you were outside the agricultural district, so that you would be waived, as you said at the beginning, so that your necessity for even getting an RUE under either set, but I'm talking about 1715 here, would be waived.
And I'll attempt to answer your question as best I can, and please correct me if I got it wrong. But I think your question is there anything under the agritourism overlay code that would change or direct the county to review an RUE differently, or critical areas for that point? And I think the salient point here is that there are uses, right? So there's a variety of uses like hay rides, farm to market sales, things that promote agritourism. And the list is long. There is actually a fair amount of uses that could be accepted. Now, typically under a certain zone, you may need to apply for a special use permit in order to allow what would be considered, not supported by, entirely directly supported by the underlying zone. Those are the kinds of things that it exempts. So, you can go ahead and have that use, but the structure itself is not addressed. And in fact, there's a provision under the AODs, I point you to 2008G0204 that says AOT activities shall comply with all applicable county health, resource stewardship, that's CPED, and public works department's requirements and standards. So clearly the code is written in a way to not, to still have standards in play, especially those that concern health and safety. And I'll add to that, you won't find, to go back to your question, Commissioner, you're not going to find a reference to, in fact, there's nothing to do with critical areas and agritourism overlay. It doesn't address whether there's some leniency if you qualify for X, Y, and Z. So again, it may support some of the activities. Now, I can't speak to everything on the property, but it's possible it may, negate the need to get certain uses permitted. But again, the structures and the impacts to the wetlands are evaluated on other parts of the code.
And we're not talking about uses. I mean, nobody's saying that they're in trouble for hay rides or something. This is about permits for structures, right? Yeah,
there's three structures that issue: a second home, a 3-car garage, and the third is RV cover. So these are all 3 different structures that they're trying to get permission, essentially get permission to build, despite the fact that there's a wetland and critical habitat in the area.
And the protection for those wetland and habitat are not relaxed when you're in an agricultural district when it comes to building structures. Is that fair?
I think that's an accurate statement.
Any more? You have a question for Travis? Mr. Burns?
I guess following up on Commissioner Mentor's question, I thought there was some relaxation on that regulatory stuff, the Thurston Conservation District works with ag properties, and it's another segment of state law. I can't think of the name of it right now, but, and they work out exemptions on just this, what we're talking about. Does anybody, do you know anything about that, Travis, at all? What I'm referring to?
I don't want to guess what you're thinking, but you may be thinking of the voluntary,
Yes,
voluntary
stewardship. Yeah,
place.
voluntary stewardship.
Process. Yes, you're right. Voluntary stewardship. That's a separate process under growth management outside the agritourism overlay issue. So that's when communities get together and put together a plan that has to be approved by the state, and then conservation district and the county follow through with implementation. But that's not an issue in this case.
Okay. Is it legal to have an outside toilet on your property? No,
I can't offer anything. I can offer everything I know about the record.
Outhouse or whatever you want to call it. Is it legal? Does the county have a code against that? Having an outside toilet? Not a Santa can. You know, a lot of old farms, that's what they had out behind the barn. I'm just asking the question, do we? Do we allow that? Is there a restriction about that?
I think it depends on the circumstances, Commissioner, and honestly, environmental health folks would be better poised to address that question.
Yeah. Okay.
Anything else?
I think I'm going to let it go for right now.
Mr. Burns, I have a question. You referred to Title 24 and Section 2445.030, subsection G, Gulf, says the reasonable use shall not result in the unmitigated adverse impacts to species of concern. And so when I looked at this caught my eye a week ago when I went through this. Then on page 7, the very bottom, section 13, that's where it talks about the Oregon spotted frog. And the next page at the top, it says planning staff submitted that, and this is speculation, I imagine, submitted that the unpermitted activities on the site are very likely impacting that species. Because now that species apparently is not there any longer, is what I've read. So my question is, with those, and again, now I'm trying to get you to think in their heads, maybe you can't. What conditions might have led to that spotted frog? Is it going to be the dumping of fish guts, or the septic tanks, or unpermitted buildings, or do we know? We don't know, do we?
Well, the trouble here, Commissioner, is the applicant has failed to evaluate any impact. So I don't even know if we know the answer to that, to be honest. And at a minimum, the department, I would think, would expect some analysis of the location and the proximity of the species. But again, the issue here is that there was nothing in the record to support how they met this requirement. And again, that's the burden of the applicant. And so when the hearing examiner finds that the criteria aren't met, it's because there's no evidence to support their application. And that's really the issue, is that very little, again, was done to evaluate these impacts. Okay, and was there any other mention of the spotted frog in here that I missed that you're aware of? You don't have to go through it, of course, but I mean, this struck me. I didn't know if there was any other paperwork anywhere else that talked about that species. So let me get to the question, though. Even if the AOD applies, doesn't apply, agriculture, agritourism, whatever, we'll get that sorted out. Does that trump the critical areas, or does that trump species protection? No, there was a correct statement earlier that if there is a conflict with the AOD, with any other provision, the AOD prevails, but there is no conflict with the critical areas. So therefore, it does not supersede critical area requirements. Okay, thank you.
I have another question.
Go ahead.
Do you Counsel, do you have any explanation of the discrepancy of the location of this? I know there's some debate whether it even applies, but is the property within the area of the AOD or not? Do you know the answer to that question?
Commissioner, all I have is the record in front of me, and I recognize it's a point of dispute. I did recognize that I think one of the comment letters relayed that information. You know, staff just didn't evaluate it from what I can tell. But again, there may be other areas of the record that may be telling. You know, whether or not there's a discrepancy over the geographical area, I guess my point is that it's harmless and it's not an issue. And there's a good chance that staff did not squarely address it, at least in their report, because of the fact that it doesn't change how the RUE should be evaluated. But again, I can't speculate to say or even guess whether or not it's in. It's not something that I was able to discern from the record. I will concede that there is a map in the application that does at least purport to show that it's within the the AOD. That's in the record, Commissioner. But at the same time, it is a little confusing because our zoning map does not, our official zoning map does not include an AOD. So there's a lot of confusion around it. I suspect if there was any error, it was harmless, but I can't discern whether or not there's an error or not. I won't be able to provide that for you.
Okay. Would you know if there are any examples of an RUE, reasonable use exception, any examples of that going through this process if it was in if and over ag issues? Do you have any, does staff have any examples that you're aware of that, we can compare it to just to know the answer to that? Have we ever had a RUE in an ag district?
It's not something I've researched, Commissioner.
Anybody from staff, anybody around that knows the answer to that?
We'll have to get back to that.
We'll get back to you.
Okay.
All right, Mr. Burns, anything further?
No, that's it for me.
Okay. Now I believe Mr. Pettit's turn to rebut.
2 minutes.
And your 2 minutes? Okay, 2 minutes.
2 minutes, then my rebuttal.
No, you have 2
Your
minutes.
rebuttal is 2 minutes.
2 minutes to rebuttal out of my 15 minutes total?
Yes, sir.
Yeah.
I have to find that to be ridiculous. Time.
Let me just, well.
Go ahead, sir.
But certainly the board has the latitude to.
I guess I just have a question, sir.
Yeah.
The amount of time that we afforded staff, if you will, Mr. Burns, did that count against anything? Were we keeping track of that?
Yes.
So he only had a certain amount of time to respond?
Right, but when it comes to question and answer, we can take up as much time
They're
as we
not
want.
dinged for our questions.
Okay.
Similarly,
Doesn't
when
count against
after
them.
Mr. Pettit's testimony, you engage in questions and answers,
Yeah.
and that did not apply to the 15
Okay.
minutes.
Thank you.
Okay, well, my first comment, since I'm going to be a short rebuttal here, is I actually appreciate Mr. Burns' comments. Like he said, the staff report that was presented to the hearings examiner was written in 2019. It did not have information related to the agritourism overlay district. The information that was provided to the hearings examiner was defective. There's no question about that. Aspirations about applying a critical area ordinance for residential is completely different than an agricultural critical area ordinance. In fact, it's insulting that staff continues to follow a line to intend to not find justice for people or correction of the record. They seek to say, well, it didn't happen because we didn't submit the right thing, so therefore you have to accept our decision that was based upon false information. It is completely inappropriate for staff to think that somehow in this process that they're entitled to get a decision to support a flawed hearings examiner decision based upon provable evidence of the wrong information, that should suddenly be that we won. You never win if you're taking away citizens' rights for use of their property. I started this process and I gave you a reading that was particular about the elements that you can make a decision on, which include, you can agree to it, you can say it doesn't work, you can adjust it, you can change the findings. You can also send it back and say, we need to start all over on this. So I'm encouraging you, please, get to the facts. There's lots of accusations. People want to say things, keep you out on an edge, but they're not telling you the full truth. They're just telling you truth to motivate you to go to their side. So, I don't know. Is my 2 minutes up?
Yes, but I don't know if you want to afford him
Thank you.
more time.
I would opt to give Mr. Pettit a little more time. I would, but that's up to my
That will be
seatmates.
up to you guys.
I'm thinking no, but I'll turn to my seatmate here.
What's your
That'd be
proposal?
Whatever, you like a 2
I don't
minutes,
know,
5
just a
minutes?
few minutes. You can't hardly get anything done in
What's
2
your
minutes.
proposal?
5 minutes, I don't know.
Okay.
5 minutes is fine.
We do 5 minutes.
Okay. Thank you. Thank you. I appreciate it. We've gone through a lot of process with these people. They've gone through 5 years, 4 years plus of seeking advice. Every action they took, filing for an RUE, was based upon the recommendations of staff. Do this, you can get what you need. Then they go through the process and, we oppose it. This is not about a staff that has helped the process. They go through their report. It's part of the record. That's what you need to go. If that report is defective, you need to find the entire process to be defective. That report is defective. As Mr. Burns mentioned, it doesn't mention the AOD. And why would it not? During the meeting with the hearings examiner, during that hearing, it was brought forth that Josh Cummings told us to bring this before the hearings examiner for consideration. And yet, now we're hearing from staff, oh, you can't consider this. You have a lot of work ahead of you if you're going to make it right. Now, as far as some of the other rulings and your question Mr. Menzer had about the setbacks for buildings, you're going to need to take a closer look at the regulations with the element of the agriculture critical area ordinance. And when I say that, there's a lot of reference that give you a direct line over to growth management, which if you read that, it very much specifies, and it's not just limited to something existing. Read your own code here. It's new and existing. There has been a fullness here of an intent to deceive you through a false report, through information that's being provided to suggest that it doesn't count for new and existing, that it doesn't count for buildings. I have provided previously letters regarding exactly all these elements. And I think that you're going to take some time. I believe you're going to take some time and you're going to look at this deeper. And hopefully, you will, in fact, make a decision based upon the law, and you're going to allow these people to use their property based upon the law and county code. That's the ultimate of what America is all about. And you're here to judge and make decisions. And once I'm going to grab this and read it off, my last time for reading this. The board decision on appeal. At the close record appeal meeting, the board may adopt, amend and adopt, reject, reverse, and amend conclusions of law and decision of the examiner, or remand the matter for further consideration. If the board renders a decision different from the decision of the examiner, the board shall adopt, amend conclusions accordingly. The board decisions on the appeal shall be issued not later than 60 days following the date the appeal was filed, unless the parties to the appeal agree to extend the time frame. We previously did extend the time frame for this hearing because of conflicts on your part. We agreed to do that. We also know that you're not going to be able to issue your decision within 60 days of the day we applied for it. So we would rather have justice and personal study on your parts, so you know what it is, not just being fed what the agenda is. I would implore upon you this. It's not about the history of the things that have gone wrong. It's about taking a road to what is right. And for that, I close.
Thank you, sir. Yes. Mel? Oh, go ahead. I didn't see you.
Okay, just as a follow-up, I thought that Doreen Millward had a I thought she was going to have a follow-up comment.
I was going to suggest the other side has 3 minutes left.
Well, then, but if they had 3 minutes left, how can?
He can't refute it again.
How can he can't rebut that.
No.
I mean, I'm all for hearing from Mrs. Millward, though. I mean,
Out of their 15 minutes, they reserved 3 minutes.
well, except now you're putting Mr. Pettit.
No,
But it's regrettable.
No, you
Yeah,
did.
that's kind of regrettable here.
Courts can, I mean, sometimes there's rebuttal and surrebuttal, and at some point, the court
Cuts it off.
has to cut it off, and somebody's getting the last bit. If they reserved 3 minutes and they were allowed to do that, I think they should be able to use that.
Right.
If we give Mr. Pettit,
Yeah.
we can give Mr. Pettit a chance. He's limited to exactly only to rebut what they say, not to add more time for some other
Okay,
topic.
I'll go along with that.
Ms.
If
Millward,
they
did
say
you want,
something he needs to address, he can do that.
did you either of you want to say something further? Yeah, she speaks for Doreen, or,
Well, I just thought that
hang on.
Doreen wanted to say something earlier, so. Oh, excuse me. I guess I'm mixing it up.
got to make a decision.
This is Doreen and Jennifer wanted to say something, I guess. You start. Okay, I just want.
We got to
I
step to
wanna
the
hear from-
podium. Okay, stop,
Yeah,
please.
okay.
Thank you. Will you step to the podium and speak if you're going to speak, please? There's 3 minutes remaining.
I'm just going to quickly ask you
Can you
to
bring
please,
the microphone closer, please?
And your name again?
Doreen Millward, and I'm just, as a closing thing here, I'm just going to ask that you please start enforcing your codes. They have been operating on this property for 4 years and multiple violations continually. That's all we want. They keep saying they want to do what's allowed in the code. Well, by God, I do too, you know. There are multiple violations, regardless of what they're saying here.
Thank you, ma'am. And Ms. Lynn? How much time?
I'm Jennifer Line, and
Fine.
it's a hard name. We want the property to be used as it's zoned, and it's constantly in the website and different places called an operation. And the first double wide that was put in under permit is used as the office. They call it the office. There are multiple cars. One day, they've been doing Tuesday, Wednesday work parties, working like crazy, and it isn't, I mean, a lot of times we have work parties and people will come help farmers out like that, but there are a lot of cars that come and go. So we don't see it being used as a normal farm situation. And I'm not pushing anything one way or the other. I'm not lying. I'm not making things up. I live across the road, and I am as honest as I can be.
Thank you. Ms. Burgess, Would you like to use any time?
No.
Okay. Thank you.
Okay.
All right, we'll give you 2 minutes, 2
Got
minutes,
something that's relevant to what was just said.
2 minutes, and then we're going to close the meeting. Thank you.
What's relevant to what was just said, I'll keep it to that point. I'm glad to hear that the one lady over there, she wants it to be according to the zoning and the laws. I'm happy to hear that. The other lady here, I would say, if you research a little further, you will find that this alleged multiple violations, many of them may be violations that were based upon not being a agricultural area, but being just a single-family residential area, in which would not have been violations at all. But rather than say that, nobody cares for a property more than the property owner. And I appreciate someone wants to follow the zoning. Part of the zoning, a very unusual element in Thurston County here, is the agricultural tourism element. That is part of the zoning. It's kind of a floating zoning over the top of the zoning, which makes it complicated. But that's all I ask for you to do is study it out full bore, clear down to the environmental parts. Thank you.
Thank you, Mr. Pettit. Now, I want to thank everybody here in this room and even down in room 152 for your patience, your flexibility with logistics, with 2 different rooms, mass separation, occupancy, for the time that we've extended this and the flexibility, your flexibility and the flexibility of the process apparently is important. And we thank you all very much. And the board will issue a written decision. Do you think it's reasonable within a week? Or we have more, do we have more information to come back? We'll get that tomorrow?
Yeah, it depends how much more time you need.
Okay, approximately a week.
I have a question about that. Are we locked in, if you say that from our position here, are we locked into rushing through something and getting it done in a week?
Elizabeth is here to
Okay.
question.
That question is for you, Elizabeth. Are we locked into a week or not?
I think, Elizabeth Petrich for the record, I think it would be a good idea to, it sounds like the applicant is willing to grant the time necessary to make a thoughtful decision. And I think it would be best to leave yourself open
Good.
to at least 2 weeks, just so that you have enough time if you need it.
Okay. I like that. So
I
2
would-
weeks or by the end of the month?
Is there a legal requirement, though, Elizabeth? I mean, I thought we were working on a 30-day window last time around.
There is a code requirement that the board should issue their decision within 60 days of the date the appeal was filed, not the date the application was filed. I don't have the dates in front of me, but so it is there is a code requirement 60 days from the date of the appeal filing. So that's why, but if the parties agree that they're willing to extend that date, then we can move outside of that time.
If I can make comment, that would be, I'd rather you take your time, study the information in full depth, and I would say that if it was done by the end of the month, that would be greatly appreciated.
When was your appeal filed, Mr. Pettit? Or do you remember the date? What the 60-day
Well,
clock is?
when we extended this one last time for 20 days after about a 45-day period,
We're probably there.
yeah, you're already there. So we have to have an extension, and my clients have no objection to an extension. Making good decisions is better than just making quick, immediate decisions. So we would prefer you take your time.
Fair enough.
So it sounds like that's okay with Elizabeth, and I would imagine Mr. Burns too. Okay. Thank you, Ms. Petrich. All right. With that, this meeting, this hearing is closed. Thank you.